I think you're in for a fantastic presentation. We got Jan and Cheryl. Jan is the Workers' Compensation Claims Manager for GMA. Cheryl is her equivalent on ACCG. Jan, take it away.
Good afternoon, everyone. Sorry if I look like I'm in a cave. If I have that light on above me, it will be very bright and a little distracting, so I'm going to keep it a little dark. Well, thank you for taking your time out today. Cheryl and I wanted to put together just a quick webinar. This is a portion of what we present at the Workers' Comp regional meetings. We have 5 in-person regional meetings that we've done all of the years. We do Tifton, Statesboro, Macon, Gainesville, and Cartersville throughout the year. We usually run between March and August. So end of January, at the latest beginning of February, we'll work with LGRMS. We'll have new information and a new presentation that we'll do with LGRMS and our partner defense firm, Drew Eckl and Farnham. And so we'll have some new information, so it's not just the same old thing every year that we do. So look out for that. So those are in person. There is free breakfast. It usually runs 8:30 to 12:30. It usually doesn't go all the way till 12:30. But it is a lot of information. Like I said, LGRMS is there. We can talk about claims afterwards or anything you want to talk about with that. So look at the schedule for 2025, probably end of January. So with this presentation, like I said, Drew Eckl also does a piece. This last year, we did a mock hearing. Before, we've done how to do a deposition on the employer side, what the attorney does, all the information we need, and all that to have a successful workers' comp claim if we do have to go into litigation. So like I said, this next year we'll try to come up with something different that is really informative and what our defense firm can do for you. Dan is going to send everything out at the end of the webinar. If you need any attachments, an updated list for ACCG for the adjusters, from GMA, that's me. So one of the slides, we're going to leave it on just a little bit longer, that has my information and Cheryl that's coming up. So we will do that. So please contact us and we can send you all the information you need. When you do come in person, there's a big old table when you register, and I have all the attachments for that. So Cheryl and I have been doing this for a really long time, 25 to 30 years each. So for workers' comp, so that's why we're coming to you with this. And so this is going to be a high level with workers' comp. So questions at the end, and if you also want to talk about us afterwards, just reach out to us. So we'll stay a minute on this slide. So there's my information and Cheryl's information. So we're the ones presenting today. Dan is on in the background. So at the end, if you have any other questions for LGRMS, you can ask him at the end as well, or reach out to your local representative. They are specific for the regions. So I think we could probably go off of that. Go ahead, Cheryl, if you want to go to the next one. So how to report a workers' comp claim. For CorVel and GMA, it's on the left-hand side. You can call a claim in. If you do call in the claim, you do receive a claim number at the end of the call. You can fax or email the workers' comp, the WC1 or the first report of injury. You can send that, fax that in, or email it fnol_@corvel.com. We do ask, if the claim is serious, please let me know. That's my cell phone. Let Jamie, the supervisor, know, or your dedicated adjuster. If it's a really bad claim, let us know. We can get LGRMS out there. We could get a field nurse to the hospital. There are a lot of things that we can do to assist. Maybe we recommend pictures. Maybe we might need a witness statement or anything like that. Same for ACCG. There's the phone number, the fax, and the email to call the claim in or send in the first report. And then Cheryl asks as well, there's her cell phone number there, her number to give her a call if the claim is serious. So that is how you report a workers' comp claim. So this slide is the one I spend the most time on, and I say that when we're in person as well. It's really important to have a solid investigation at the beginning of the claim. These claims have a long tail on them. A normal workers' comp claim in Georgia has 400 weeks of exposure. It's a very long time. We want to make sure that if we're accepting a claim, that it is compensable. So we do that investigation. I just can't say how important this is. If something happens and you are questioning the claim, even if it's a minor question, just something doesn't sit right with you, please let them know when you're submitting the claim. Let Cheryl or I know, let an adjuster know, let somebody know it just needs a bit of a deeper dive. So we just really ask you that so we know where you're coming from. We'd hate for 6 months down the road after a claim that you think, I kind of questioned this from the beginning and we didn't have the opportunity to do a deeper dive on something. So CorVel and ACCG, the adjusters need the details of the accident. So if it just came in that someone fell, we need the details, when, where, how, and as the HR person, if you don't know that, that's fine. But we do need to reach out to the supervisor or the lead or somebody to get the information on how the accident happened. So we do need the details. We do not expect the member to be a workers' comp adjuster. If anyone is interested in a change of career, let us know. But you all have enough on your plate. We do not expect you to do all these things. If you happen to have a witness statement, that's great. If there's a police report involved, since it's going to be probably your vehicle, you will have it first. We do ask to send that to us as soon as you can. But other than that, all of this, the follow-up and the investigation can be done by the adjuster. But if you happen to have it, that's great. But no detail is too small. So for example, if you have an employee, we'll call him Bob, and if Bob wanted to take the week of Thanksgiving off and you just couldn't make it happen, and Bob has an injury the Monday before Thanksgiving, that might, at 8 o'clock in the morning, that might be a little suspicious. So we do need something to look into. So again, excuse me, no detail is too small. Please let us know. That way we can make sure that we're looking at everything we need to. So we have 21 days from the employer's knowledge of the claim, usually the date of injury, to determine compensability, 21 calendar days. So it does seem like a long time, but you think about it, you have weekends. Say the claim gets reported to the claimant administrator a little bit late, that can eat into the time. So it does take time to get all the information, to complete the investigation, to follow up on the medical notes, to follow up with the supervisor, to follow up with the claimant to get their statement if we need it. And then vice versa, we don't want to wait someone go 3 weeks without getting a payment. Per statute in Georgia, we do have that amount of time, but we really don't want to wait and make anyone wait that long. So a lot has to happen in those first 21 calendar days. So we do ask, as soon as the employee knows that there's an injury, that they report it to the supervisor, to HR. However you're reporting claims, just please get it to the claim administrator as fast as you can so they can start with the investigation on it. So the other things we're going to talk about are below. So the aggravation of a pre-existing injury. So in Georgia, that can be compensable. So if you have an employee that comes to you, say I'm your employee and I'm in my late 20s, I wish, and I had a shoulder injury during high school and you knew about this on my right shoulder, and I come to you and I'm 28 years old, so 10 years later saying I hurt my shoulder at work. As an employer, you can't say, well, you had an injury in high school. That doesn't matter. You can't, you already had that coming in. It doesn't matter. If something happens at work and an employee alleges that they re-injured themselves or injured themselves at work, you must report the claim to the carrier. Let them ask those questions. So in that other example, if there hasn't been any treatment in 10 years, they injured their shoulder at work, it's likely going to be a compensable claim. Say that they've been treating for those past 10 years, and there's even recent diagnostic testing. If they allege they injured themselves at work, we need to go to the doctor and see, okay, what's baseline? What was the prior and what was after? And if there are diagnostic testing that we can prove and kind of go through that, the doctor has a little bit better of a gauge to confirm, but we've got to get them back to baseline. So something to think about with aggravation of pre-existing injury, likely is compensable. Willful misconduct is something, so workers' comp is a no-fault system. However, if someone's doing something egregious and breaking a serious safety violation, we need to look at that for willful misconduct. It is a high bar to prove, but we just don't want us, not pay attention to it and not dig into it a little bit deeper. For example, say there's a wood chipper and you are clearing logs and there's a wood chipper and everyone's been through a safety course. Everyone knows the safety, it's been written down. The supervisor is really good about monitoring this, and say an employee sticks their leg in because there's a jam while the shredder is on. A leg versus a shredder is not going to end well for anyone. That could be willful misconduct. It could be something we need to look at. However, if it's not consistent, if there's been no safety, if the employee was not trained on the machine, things like that, if everyone else, if I'm gonna pick on Bob last week put his leg in there, the supervisor even uses his foot to kick it through, if there's a jam, that's a problem. We don't have a chance to prove a willful misconduct. So that's why safety meetings, documentation, and consistency. Consistency is a key word. Everyone needs to be treated the same. So to keep your employees safe, when they come to work, leave work, just if the supervisors are seeing something, please say something. We want to make sure that everyone's treated the same. But if there's something like that we need to look at, you know, it could be a willful misconduct. So please mention that, you know, with the safety when we're looking at the claims. So the next one is intoxication. Intoxication has to be the proximate cause of the injury. So while I'm talking to you today, if that ceiling fan that's off happens to fall on me today, the intoxication is not the proximate cause of the injury. There's nothing I could have done. However, if I stick my leg in a wood chipper and I have a positive drug screen, we could allege that the intoxication was likely the reason that I made a bad decision and stuck my leg in a wood chipper. So something to think about. If it's a passenger in a vehicle and they weren't driving and the accident happened and they took a drug screen, again, the person's in a passenger, there's nothing that their intoxication could have done to prevent the accident because they're a passenger. You're going to have an HR issue on your hand, but just because they test positive, we can't deny workers' comp for them. So something to think about with intoxication. Another important, very important thing is we need to prove intoxication within 8 hours of the accident. So if someone alleges an injury, whatever your rules are, your policy is, follow those for drug screens. So we need, if it's, you know, if you're doing everyone, if you're only doing certain people, whatever your policy is, just follow through with that. And again, it just needs to be consistent. So the next one, ingress, egress, to and from work. Employees usually are not covered to and from work, even if they're in a city vehicle, even if they are in uniform. So I'm going to give you some examples. So if you're an officer to and from work, it depends on when your duty starts. If your duty starts in the driveway, you're driving to and from work, it depends because we have Cheryl with the county and you have me with the cities and municipalities. Depends on where they are officially clocked in and when they are in police mode. So if they are driving to and from work, and they start there either when they hit the city limits or, you know, after they go to the precinct and then they start, to and from work is not compensable, driving to and from work just like any other employee. However, if they go into police mode, I'm an officer, I'm driving to work and I engage in a chase and I am in police mode and an accident happens, that's likely going to be compensable. So for public works, same thing. They're driving to and from work and in a city vehicle, it likely not compensable. The automobile is going to be covered under your liability claim, most likely. But another example, say I'm a detective and I get called in at 1 o'clock in the morning to go investigate a scene and I'm leaving my house, this claim like this happened, slipped and fell, getting into the car because it's dewy on the ground, that's going to be compensable. Accident happening when somebody's called in after hours, likely going to be compensable because that's a different situation. So the ingress and egress is probably going to create some questions. I'm happy to answer those at the end. We can kind of go through the scenarios. If you'd like to report those claims to Corvell and ACCG and let them be investigated, by all means, please do that. That way we can make sure we're looking at everything to see if it would be covered under work or not. But something we want to talk about with those things, that's a big misconception of what's covered or not covered under workers' comp. So the last thing after I went through all of these things, and I hope y'all are still with me and awake, went through a lot of stuff here, our responsibility is to investigate every claim. It's not to deny these claims. Cheryl and I do not look at these claims and say, oh, how can we deny anything? That is not why we are here. But we want to make sure overseeing these programs that if it's compensable, we owe it. We're going to pay what's owed. But if it's not compensable, just because it happens at work doesn't mean something's work related. So if I'm talking to you all today and I have an incident and pass out for some reason, that's not work related. Now, if I hit my desk on the way down, the laceration, or if I hurt my face, could be. But so something, like I said, just because something happens at work doesn't mean it's work related, but that's give us time to investigate these claims, see what's compensable. And again, like I said, if it's compensable, we owe it, and we're going to pay what we owe. Next slide. I promise that's the longest slide. So who is covered and when? Full-time employees, part-time employees, volunteers, firefighters and police officers. For the volunteers, if you have a resolution passed, if you're not sure after this call, reach out to Cheryl and myself, and we can let you know if your volunteers are covered. Also elected officials, if a resolution is passed. So don't assume, let's check. If it's been a while and you want to confirm that, please let us know. We are happy to follow up with you just to make sure. If you need assistance and how to pass a resolution, we can assist you with that as well and give you the tools that you need. And if you want prices, we can follow up with you with that as well. Temporary employees also. And when are they covered? First day on the job. There is no waiting period, time limit. If they are your employee at 8 a.m. on Monday morning and they have an accident at 8:05 and it's compensable, it would be covered. So there is no waiting period for anyone as long as they are your employee. So the panel of physicians. This is very important. The panel of physicians and the Bill of Rights need to be posted together. It can be from July of 2022 or July of 2023. 22 still has the blocks on it. 23 has the lines on it. So they changed it. Either one is still fine and valid as a valid panel. You need at least 6 physicians. There's a list of how a panel is valid. If you find out that one of the panel providers moved, retired, any changes, please let us know. We can get that updated. Internally, Corvell and ACCG try to monitor those if someone does change, but you may know in your area that that's changed, so we need at least 6 on there to be valid. Valid phone number, address, and that they are accepting workers' comp. So it's a list of physicians. It must be in an obvious area. It must be presented and explained to them when the employee is hired. Very important. If you haven't done this in a while, or say you're newer and you have employees that are there a while, if there's an opportunity or a time when everyone's together, I know open enrollment may have already left, but there's an opportunity to explain the panel to everyone and make sure I have a form that I can send you all that I understand the panel of physicians and where it is. Have them sign the panel. Here's a current copy of it. Have them sign an initial that they know that they've seen the panel of physicians. It is helpful to have that in their file so later they can't say, no, I don't know what the panel of physicians is or how it works or what I'm supposed to do. So it must be posted by the Bill of Rights. The Bill of Rights is kind of like a Cliff Notes version of a really tiny writing of just a basic overview of workers' compensation in Georgia. They must be posted together. And the employees, the purpose of it is the employee is going to choose a doctor on the panel of physicians when they're injured. So the employee, if I injure myself and Cheryl's my supervisor, I was like, oh my gosh, I injured, I've got a laceration in my arm. If it's urgent, we like to get them, to the nearest urgent if something is a bad injury. And if I come to Cheryl and sorry, I do have a cast on. So say I broke my hand and my bone's sticking out, probably not the best time for Cheryl to show me the panel of physicians and me to pick a doctor. Someone's going to get me, either call 911, get me to the nearest emergency room, or to an urgent care. So let's get the urgent treatment done, and then they're going to circle back to the panel of physicians. But say I just have a strain, say I strained my shoulder, I'm going to tell my supervisor. The supervisor, Cheryl's going to say, okay, pick off the panel. I'm going to say, okay, I'm going to go to this urgent care, and I'm going to head on over there and go for treatment, and then they're going to report the claim to the claim administrator. So that's what you're going to start on with the panel of physicians.
Can I add something to that? Especially if it's an urgent situation and you are going to the emergency room, if you can prevent them from using a health care insurance plan, we are having the hardest time to get bills from them, because once they get their money, they don't want to be bothered with us, and they have the right to bill the injured worker for the copay portion, and we can't pay the bill based on copay. So if they can do it like self-pay, if you know it's ACCG or GMA, just give them the Social Security number as the claim number and our address for the payer, and that'll help us with that process of getting these hospital bills paid because we are in battle with the healthcare providers with that.
And that is a very good point. It is difficult because if anyone's been to their urgent care or hospital lately, they probably have that information already in the system, but it is so hard to unwind that. Just tell them when they go in, self-pay, it's workers' comp. Just please don't bill their health care for that because it is so difficult. Number one, we are fighting to get bills. So if the employee has bills and they're getting frustrated, just make sure you're getting those to the adjuster. Our adjusters are begging for bills. We're begging for to get those paid for you. So it is something that is ongoing that the adjusters spend hours a day on the bills. So here's a little supervisor checklist. So I kind of combine the supervisor and HR together. So first, if someone alleges an injury for workers' comp, direct them to the panel of physician, report the claim immediately to the claim administrator, give them what you have. We'll take it. We just need to get running with it so we can start looking at the claim, if it's compensable, get the injured worker what they need, and move on from there. If they miss more than 7 calendar days, so this is important. Shift days do not matter in Georgia workers' comp. It is calendar days. So if they miss more than 7 calendar days, we're going to need a wage statement. And I know it's not very fun to fill out 13 weeks, but I always tell people, if you've been on site or heard my training before, it could be worse. Some states are 52 weeks. So I know 13 is not fun, but it could always be worse. So we need 13 weeks prior to the date of injury. Not including the date of injury, the weeks that you have cannot have anything to do with any time after the date of injury. So all has to be before, and that's how we get an average weekly wage. So we need those 13 weeks. The adjuster will send a wage statement to you to complete. And if you have any questions, ask the adjuster. That's what they are there for. They are there to hold your hand through this process. And send everything you have to them. If you have a witness statement, great. If you have pictures, especially car accidents, that's phenomenal. Please send the pictures. If it is your vehicle, you will get the police report. Please send a copy of that. So if we know there's subrogation, we can go after that. Any disability notes, if the employee brought you anything, a work status from that initial urgent care, please send that as well. And the adjuster will ask this for you once they get the claim, but it's just something to think about. Whatever you have, send it on. And also communication. Communication is huge. Communicate with the employee, with the adjuster. And it's everyone's responsibility with that. So if someone is out of work, please let us know so we make sure they're with a lost time adjuster. If someone comes back to work, sometimes the adjuster is the last one to know. So just make sure that we know that the employee did return to work so we can stop the benefits. Or if they're working modified duty and then they can't, we need to know that too, that if they're suddenly not working, we need to look at that. We need notes from the doctor. We'll need to get a wage statement, and we just don't want the employee to go without payments. So it is important, and I think when there's communication, it's better on everyone. Everyone knows what's going on, and the employee's not there at home with no one communicating. They're in pain. They're unsure about if they're going to get paid, and we just don't want to see them, be upset or go get an attorney if they don't have to. If it's just something that we can be helped just with good, consistent communication. So benefits, they are based on the date of injury. The last time Georgia increased benefits was 7/1 of 23. So some states make changes on January 1st. Georgia makes changes to workers' comp on 7/1, so July 1st. So the max now is $800, but it's the wages, the earnings that you have, the TTD rate is based on your date of injury. So if someone had a date of injury in 2005, that's going to be different than an injury at 10/1 of 2023. So it's based on the date of injury. Again, we talked about this before. It's 7 calendar days of disability. That's the waiting period. All states have a waiting period. The majority of states, it is 7 days. And this is due in Georgia if you miss 21 days. It's also important to let the adjuster know if the employee chose to use sick time. Now, all my cities do everything different. Some will let them use their sick time, some don't, some will do a portion. It's all different. All of it's different, but just whatever you're doing, just make sure it's consistent. Make sure the adjuster knows if you've continued wages beyond the date of injury, let them know. We don't want an underpayment and we don't want an overpayment. So just, again, communication is important if you've paid anything beyond the date of injury. So the average weekly wage, that's why the wage statement is important. We take an average of those 13 weeks prior to the date of injury, and we get 2/3, 66 and 2/3 or 2/3 of the average weekly wage. The max is $800, and it is not taxed. So in case, we always get those calls in the spring because the tax person says it's taxed, workers' comp is not taxable. The temporary partial rate, say someone has modified duty and you can accommodate some of that, a portion of that. So the max temporary partial rate is $533 per week, again, not taxed. And on this slide, this is not something, I should have said this before, we are not going to be tested on this. These are not things that we expect you to explain to the employee. You might know a little bit about it. We just want you to make you aware. If the employee comes to you and asks you questions, you're like, oh yeah, they were talking about that. This is what this means. That's fine. The adjuster will be explaining all of this to the employee. I just like to make sure that the members know this is how it works and this is what it is, and kind of like that. Anytime that you 6 months down the road, 3 months, you have a claim, Cheryl and I are happy to go over this with you again, or the adjuster or anybody. So if there's a permanency rating, we're going to go back to body. I mentioned the shoulder. So if I have shoulder surgery and I'm just having loss of use or some pain or tingling, it's just not right. Even after the surgery, the doctor places me at maximum medical improvement, and I might get a permanency rating. So every body part, head to toe, in Georgia is worth a number of weeks. The whole body is 300, arms and legs are 225 weeks. The fingers are worth something. The hand is worth, the wrist is worth 160 weeks, I believe. So everything is worth that. So my shoulder, my arm is 225 weeks, and say I get 10% a permanency rating, that's 22.5 weeks of my temporary total disability rating. So that is owed to them. We have to pay that. It is not a settlement. And I know a lot of employees are frightened or nervous to, I don't know if I cash these checks, am I settling my claim? You are not settling a claim. There is no, they don't have pain and suffering under worker. So that's why they came up with a permanency rating in a lot of jurisdictions. So that is one in Georgia. So we do have to issue those checks. It's owed to the employee. I could be full duty at maximum medical improvement and still get a permanency rating. Or I could have surgery and be fine. I'm fine. And you may not get one. So it's up to the doctor. The doctor is the one that decides based on the AMA guides. I believe we're on the 6th edition right now. Of if there's a permanency rating. So that's, but we do have to pay that within a short amount of time. So that's what the permanency rating means. So there are death benefits as well. If an employee dies and it's a compensable in the line of duty or related to workers' comp, there are death benefits owed to the any dependents. So that is something that the adjuster, Cheryl, I can also explain to anyone. And so the last piece is it's terminated. So if the employee returns to work, if I am released to full duty, I'm expected to return to work. If I don't return to work, we can terminate benefits with a 10 days plus mailing, so about 14 to end that. If I'm released to modified duty work and the employer can accommodate it, I'm expected to return to work, the employee is. If they don't, please let the adjuster know. There are other ways to go through that. You can also settle the claim. We cannot force anyone, but we could settle the claim. Settlement would end the claim or by an order from a judge. So, for example, if we have an employee that is non-compliant with medical treatment and they've missed 2 appointments, we cannot just terminate benefits. We can't terminate benefits just because we don't like someone. In Georgia, it's very difficult once you have accepted a claim to terminate benefits. So if they have to return to work, if they're full duty and don't return to work, we can do it that way with some extended benefits with mailing time. We've settled the claim, so it's a settlement order, or we're ordered by a judge. So those are things, again, that the adjuster can walk through you with and explain, but I just wanted to be clear on that piece. And that is it on that. So I'm going to hand it over to Cheryl.
Okay, so my portion is about the life of a claim. So we're gonna go over the record only, medical only, lost time, and litigated claims. So a record only or incident only, depends on how you want to word, is a claim that was just reported to us with no medical treatment, no lost time, it's compensable, and pretty much once we get it, we set it up for closure. So that's what we consider a record only. If you just want to just put it on record, noting that the person got injured, but they don't necessarily need medical treatment. So that's what we consider a record only or incident only claim. A medical only claim is no lost time beyond a 7-day waiting period, and they're only receiving conservative treatment. is the member report the claim to the claim administrator. Now, GMA do not make contacts on the medical only. ACCG make up to 3-point contacts on medical only, depending on what type of claim it is. So the claim is set up, is assigned to adjuster. The adjuster have 1 business day to contact the member, the provider, or the injured worker. And if they can't contact them by phone, they'll follow by email or, I guess, letters. So sometimes we do have to send out letters to our contacts. The adjuster can schedule appointments. They can order durable medical equipment and a physical therapy, diagnostic, whatever is needed on the claim. The medical only adjuster can do that for the injured worker. Once the claimant is reached medical maximum improvement, the bills are paid and the file is closed. Now, if sometimes you might get an impairment rating on medical maximum improvement on a medical only. If an impairment rating is assigned to it, it will be reassigned to a lost time adjuster just to pay out the impairment rating on the claim.
And with GMA, if there is a medical only claim and the employee does need to be contacted, the adjuster is happy to, it's just not in their normal protocol, but if the employee has questions or does want to follow up, please let them know and they will. I just don't want them to expect a phone call. They're happy to reach out to the employee and discuss and answer any questions that they have. The adjuster can do that.
Right. And then we have a lost time claim known as the indemnity claim. This is lost time beyond the 7 calendar waiting period. The claim is reported to us, is assigned to adjuster. Of course, the adjuster have a 1 business day to contact the member, the employee, and the provider. And if they're unable to reach the party, again, they would do it by phone, email, or letter to let them know that the file, they are trying to reach them to get additional information about the injury. The adjuster will coordinate the medical treatment, again, with the appointment, physical therapy, diagnostic tests, durable medical equipment. We also have telephonic case management on the file. So if it's something severe, we will assign a telephonic case management to the file that will help coordinate with the medical treatment, especially if they need surgery, and they also help with the return to work day. So you also have a TCM, which is a nurse, telephonic case manager on the file, as well as the adjuster. So if you have any question, you can contact either one of them pertaining to the medical. Like Jan mentioned before, if it's a lost time claim, the adjuster will send out a wage statement asking the member to provide us with the wages so we can start them up on their benefits timely. So again, if we got 21 days to determine compensability, we also have 21 days to pay them timely and make sure we don't pay any penalty. But of course, we want to pay them before the 21 days because nobody shouldn't go beyond 7 days without payment. The employee returned to work, modified full duty. Then of course we will terminate the benefits. Again, we have a nurse on the file. So the nurse will probably get the work status. She will contact the injured worker as well as the member and the adjuster, let them know, hey, either they on light duty or they released to return back to work. So you'll get notified either by the TCM or the adjuster. The injured worker should be telling you if they've been released to light duty or not. Again, that come back to communication with each other, making sure that your injured worker communicate with you and the supervisor communicate with them to let them know if they released to modified duty or full duty. Once the employee is placed on medical maximum improvement, the adjuster will confirm the rating and then pay accordingly. So again, it depends on what the rating is. They are calculated based on the body part with the TTD rate, and it will be paid out weekly until it's paid in full. Once that's paid in full and no additional treatment is needed, they would follow with all the outstanding medical bills and they would pay them and close the file. If an employee is released to modified duty and refuse to return to work, the adjuster could do a 240 process. A 240 process is they will follow with the member, determine if light duty can be accommodated. If light duty can be accommodated, they will ask you to fill out a form with the restrictions. Once we get the restriction, we will send it to the treating physician. to see if they will agree to it. Once the doctor agree to it and sign off on it, then we give them like a 10-day notice to return back to work. Now, if they fail to return back to work in that 10 days, then we can suspend their benefits. But if they do return back to work, which we hope they do, we'll suspend their benefits at that time. Litigated claims, that is notice of rep is filed by the employee attorney. So you guys will probably get a copy of a WC-14 at the same time as we will. Sometimes it's just a notice of a claim showing that they are representing them, or if there's a request for a hearing. Now, if it's a request for a hearing, we do have 21 days to assign it to counsel to defend the county and ACCG and GMA. The notice of a claim is just a notice of representative, meaning that he is now hired attorney. The adjuster is no longer able to speak directly to the employee. Now, if we do have a nurse on the file, the nurse will follow up with the counsel and ask them, can they, speak directly to the claimant, just about medical portion only. And sometimes they will allow the nurse to do it, sometimes they won't. So it just depends on the attorney. So if there's a request for a hearing, meaning that it's been assigned to a job and is to a judge, and a hearing date will be set, that's when the adjuster needs to assign it to defense counsel. The defense counsel will notify the member and contact you for discovery, and they will be asking for, their payroll records, personnel record. They might even schedule a member deposition or a supervisor deposition. It just depends on what the issue is, but they are going to be assigned to the file to do written discovery to help the adjuster assist with this claim. If an employee attorney requests anything from the member, please do not give it to the claimant attorney. Please notify the adjuster, or if we have assigned it to defense counsel, have it send it over to defense counsel so they can respond to you. So they should not be coming directly to you. They should be coming to the adjuster or the attorney assigned to the file. Many hearing dates are set in order to complete discovery, and 9 out of 10 the case is not going to proceed with the hearing. It's going to be rescheduled several times. But if it's up to our attorney to complete the discovery. If necessary, the member will give a deposition or testify. The defense counsel will explain this procedure with you, go over everything, and communicate this directly with you. 9 out of 10, it usually don't get that bad unless it's a really severe injury. But other than that, most cases continue, and we try to get them settled before we have to get into deposition from the members, the employees, the co-workers. So this, if a case goes to hearing, just remember that our attorney might contact you to get your deposition or to testify at the hearing. This one is the claim made settled prior to going to hearing again. 9 out of 10, we try to settle cases before they go to hearing because we don't really want to take you away from your job. If we can resolve the issue, then that's what our goal is, to resolve the issue prior to going to hearing. The hearing take place, there are briefs to be filed, the judge issue order, either side can appeal. So if we go to hearing and the judge hear the case, so the judge hear the case, our attorney and the claimant attorney have to file brief. Once that is filed, the judge will decide which way to go. Either we can win or lose, and depending on the case, if we feel like we have a 50-50 chance of prevailing, we might appeal, which would delay, I think it's 180 days, an extra 180 days before we get a final answer on the case, whether we won or we lost the case. Okay. So the next one is the PTSD program. This is just a House bill that's going to be passed. It has been passed, but it's going to affect it January 1st, 2025. This is a program for the first responder that diagnosed with PTS. It's something that is going to be private. It's not going to be privileged to the members of us. The information is listed at the bottom with the email or the address, the email address or the contact name, you have Lindsay and Megan, and they can contact them to get the information how to proceed with that. That'll be something that ACC and GMA is not really privileged to, but it's this bill that's passing for the first responder about this program. This is not going to be part of your claim. It's private, so it's confidential. So the member or the adjuster will not be involved in this program. So we won't have information about this program to share with anyone. Our services are for the first responders. That's the OPSS program, the Office of Public Safety Support, and then the State of Georgia Public Officer Indemnification Program. That is something that the state offer to our first responders. It's like an extra program available for them for benefits. So if one of your first responders get hurt, whether it's just a serious injury or death, you can contact the state and they will walk you through this program. You have to apply for. Is this an extra program that they offer the first responder that workers' comp don't offer them? It's like an offset.
Those slides are there. If you want to go through the slides, there are brochures that on the next one. There you go.
Okay.
So that's the Office of Public Safety Support.
Yes. So this launched on 7/1/2019. This is for all public safety personnel, including law enforcement, firefighters, emergency worker, correction, and 911 dispatchers. This really is a support for counsel and mental health profession. Again, this is just another program that the state offered. Is privileged, is confidential. It would not be part of your claim, but that's something that you can offer your first responders if you feel like they need some additional counseling or counseling to help them through anything, especially when it's work related. If they having, stress from an incident or the job, this is something that you can offer them. Same thing, the State of Georgia Public Officer Identification Program. This this is like a program that pay extra benefits to the injured worker, especially if you have a severe injury or death case. Is this a benefits, extra money? Because again, workers' comp only pay 2/3 of your average weekly wage with a max of $800. So this is like an offset program. You have to go online or call them to apply for it. You have to apply for these benefits within 60 days of the incident. And I think it's Susan Sutterstrong is head of this program. She will also guide you on what you need to do to apply for this program. Oh, and one more thing, and I forgot to add this to this, Jen, is the Kids Chance program. The Kids Chance program is a scholarship program for catastrophic injuries. So if you have any workers that sustain any type of catastrophic injury, please go to kidschance.org and they can apply for a scholarship when they go to college. So for instance, if you have a death case and you have small children, the adjuster should be telling the spouse about it, and they can go ahead and enroll them at the age of 2 or 3. And so when time for them to graduate high school to go to college, they will notify them of the Kids Chance in the program and the procedure, how to get the scholarship to help them go to school. So, and only thing that's left is question. You have anything else to add, Jan?
I do not. And the last two programs are funded by the state, the indemnification program and OPSS. And I have brochures on those. If anyone needs those, I can send those. Just please let me know. And I was gonna turn it over to Dan to see if there are any questions in the chat, or if anyone wants to pipe in and ask anything.
So are there any questions out there? Anybody have anything to ask? Are you awake?
Is anybody left?
Coffee? Did anybody pass out because of excitement? No comments, no questions. Would anybody like to thank Cheryl and Jan for their efforts?
If anyone does have anything that they just don't want to share with the group, please just give us a call. Let us know. We're happy to help.
I'll go ahead and put out.
Thank you for all your time. Yes, thank you. Got lots of thank yous there. So Cheryl and Jan, thank you so much for your time. I really appreciate it, and for your expertise and information that you provided. As I said at the beginning, I will be recording this, or I am recording it. I'll be sending out an edited version of that to everybody that registered, along with the PowerPoint presentation. So as always, please don't hesitate to let me know if you have any questions or concerns, whether it's work comp or anything else. You are our members. There's nothing that you can ask that we would not try to help you out with. So thank you so very much. Everybody have a fantastic day. Jan or Cheryl, have anything else they'd like to say?
Nope.
Well, I'll let you guys go. Thank you so much. We'll
Thanks,
talk
everyone.
later.
Thank you.